and welcome to NTV Wild Talk with me, Smriti Vidyarthi. Today we're coming to you from the Milimani Law Courts here in Nairobi. Now the show today is focusing on the judicial process when it comes to wildlife crime cases. When we were in Nanyuki for the Giants Club Summit at the end of April, the organization Space for Giants put together a mock courtroom to demonstrate what happens in many courtrooms across the country and the continent when prosecuting wildlife crime cases. Now led by Shamini Jayanathan, the legal director for Space for Giants, 4 scenes were acted out by Shamini, Liz and other actors to give us an example. She says that the court process must be addressed. Now the first scene demonstrates what happens when the first accused person first appears in court.
He's just been arrested, he's coming to court to be arraigned and face the charges. And the 2 most important decisions that a prosecutor makes at the beginning of a case are the decision whether to charge him and what to charge him with, and also the decision to bail. John Abwa will be playing defence counsel, Elizabeth Gatari will be the prosecutor, Samuel Githoy will be the clerk of the court, and Jared Akula is going to play a police officer and also a witness in one scene. And Rod Potter is obviously going to be the defendant. Let's begin.
Accordingly, Your Honour, the prosecution calls for an adjournment in this particular case.
All right, I'll grant an adjournment. I think you're needed, Madam Prosecutor.
We'll just have a moment.
We'll call the next case on, please.
The state against George Okello.
Do you have a charge sheet?
I do, Your Honour.
Right. Stand up, please, Mr. Okello.
George Okello, you are charged on this date with an offence of being in possession of wildlife trophy, contrary to Section 4 of the Wildlife Act 2015. Namely that on, can you fill in the dates, please? On the 26th day of April 2016, at 16 Riverside Lane, Victoria County, you were in possession of 20 kilograms of ivory horn without permit. Do you plead guilty or not guilty?
Not guilty.
All right, you can sit down.
Your Honour, may it please you, may I be placed on record on behalf of the accused person?
Certainly. Madam Prosecutor, how many witnesses are required in this case?
We will have 3, 4, 5, Your Honour.
And how many days for trial?
3.
Trial set for the 6th of June. What's the bail position?
We do oppose bail, Your Honour.
On what grounds?
It's a serious offence and the ivory is worth a lot of money.
Isn't this rhino horn?
Yes, sorry, my apologies, Your Honour. Yes, it's rhino horn and it's worth a lot of money. And if this gentleman is convicted, he will definitely go to prison.
Well, I'm not sure he will go to prison. I mean, rhinos are just wild animals, a little more than large cows, aren't they? All right, is that all you have to say?
Yes, Your Honour.
Counsel?
Your Honour, we wish to submit that suspicion, however strong it may be, is not a basis for conviction. We pray that the accused person be admitted to bail for reason that he has no past conviction record. He is an esteemed member of the community and at the same time is an official in the local county. And being admitted to bail is a constitutional right, and we pray that he be admitted to bail.
I totally agree. I see no reason to hold this man on custody on any charge concerning wildlife. Bail is granted. You can leave the court, Mr. Okello. What is it, Madam Prosecutor?
Your Honour, if I may seek leave of court to amend the charge sheet.
To what?
Apparently we do have an additional charge for possession of a firearm.
Right, do you have anything to say?
Your Honour, I wish to express my deepest disappointment because this is an ambush from the prosecution.
Well, however sloppy the prosecution case may appear at this point, it is your client's first appearance. I don't see that he's a real risk of a miscarriage of justice. I'll allow the application. Have you drafted the charge?
No, Your Honour.
Right, I'll give you 5 minutes.
Thank you.
Court adjourned.
So that was scene one of the mock courtroom session played out by Shamini Jayanathan, Liz Gitari and other actors as well, giving us a sense of what really happens in some of our courtrooms when wildlife crimes are being heard. Here now is further explanation from Shamini about what really went on.
So in that scene, what we have here is a prosecutor being asked to make a decision on charge and on bail whilst on her feet handling sometimes as many as up to 60 other cases in a busy court listing. She's had no time to read the papers, no time to assess the evidence, no time to consider ancillary legal orders, no time to even address her mind as to whether in fact there is a case. She's entirely reliant upon the opinion of the investigating officer, who may not be aware of all the relevant legal points that pertain to that particular case. Accordingly, when a case gets started like that, we can see that she's already annoyed the judge at the complete waste of judicial time. She's already at a disadvantage, and she's likely going to spend the rest of that case putting out fires.
And now we move on to a second scenario that provides a very simple solution.
The state against Judge Okello.
Are you ready to proceed, Madam Prosecutor?
Yes, Your Honor, I am ready to proceed. I had a pre-charge conference with the investigating officer in this case, and we are preparing two charges against the accused person. One, possession of the proceeds of crime, being a rhino horn in this particular case, and two, illegal possession of a firearm, Your Honor.
All right, we'll hear the charges.
Stand, please. Judge Okello, you are charged on this indictment with 2 counts. The first being 1 count of possession of proceeds of crime, contrary to Section 38 of the Proceeds of Crime Act, namely that on 26th of April 2016, you were in possession of a proceed of crime, namely 20 kilograms of ivory horn, contrary to Section 38 of the Proceeds of Crime Act 2014. Do you plead guilty or not guilty?
Not guilty.
On the second count, you are charged with possession of a firearm, contrary to Section 2 of the Firearm Act 2000. Namely that on 26th of April 2016, you were in possession of a specified firearm, namely AK-47, without a license. Do you plead guilty or not guilty?
Not guilty.
All right, sit down. How long is this trial going to take?
Your Honor,
Yes?
may it please
Of
you.
course.
My name is John Abor. May I be placed on record on behalf of the accused person?
Indeed. How long is this trial going to take, Madam Prosecutor?
I intend to take 4 full trial days in this particular case. I have 6 witnesses, including a forensics expert. I would also like at this stage to indicate to the court that we are currently we have ongoing investigations, financial investigations under the Proceeds of Crimes Act. I would also like to inform you that this morning we lodged an interlocutory application at the High Court asking for the freezing of the defendant's assets.
Very well.
Duly and consequently then, if in the event that he is convicted, I will still be coming before you asking for forfeiture of his vehicle where the items are found.
Very well. Defence Counsel, what's the issue in this case?
Your Honor, this is a classic case of mistaken identity, false accusation. It is not him.
Well, all right then. Are you disputing that it's rhino horn? Do we
No.
really have to trouble a forensic expert to come to court?
Your Honor, at this particular stage it is an allegation. It is up to the prosecution to prove their case.
Yes, well, I do know that, Mr. Bois. I'll set it down for a pre-trial conference on the 4th of May, so we can hopefully narrow the issues down. Trial is set for the 6th of June and all disclosure to be completed by the 30th of May. Prosecutor, what is the bail position?
Your Honor, we do oppose bail, and on 2 grounds. One, the seriousness of the offences under which the accused person has been charged. In the first count, if he is convicted, he faces a minimum conviction and prison sentence of 3 years in prison. And on the second count, a minimum imprisonment sentence of 5 years in prison. The second reason that we're relying on, Your Honor, is that this case is heavily reliant on identification evidence, and our key witness who recognizes and has undergone a successful identification parade with the accused person is very well known to the accused person, and in the event that he is released, he is definitely going to tamper with that witness.
What do you have to say about it, Mr. Dubois?
Your Honor, mere allegations is not a basis for conviction. We pray that accused person be admitted to bail. Is an esteemed member of the community. Is a very highly ranked person working within the county. And at the same time, bail is a constitutional right. And therefore, we pray that the accused person be admitted to bail.
I would have thought the fact your client is a public official rather aggravates the position, Mr. Abois, given what we know about the illegal wildlife trade and its links to corruption and transnational crime. Bail is denied.
Court adjourned.
So the mock courtroom session really is getting more and more interesting, and this really is what happens in some courtrooms. Shamini now explains further.
The key to the efficiency and strength of the prosecution presentation at that first appearance is very simple. It was early engagement with the investigation authorities. It was early engagement with the police, and behind the scenes a more prosecution-led approach to investigations, coupled with guidance on bail that can be offered to officers so that they can put a coherent argument towards the prosecutor relating to the issue of bail and allow her to consider all the facts. The prosecutor is in a much more strengthened position when it comes to that first appearance at court. Here in Kenya, a very simple toolkit, this is the second edition, the first edition was done last year, was created. And it creates it's called a points to prove guidance, and it sets out all the ingredients in a very simple way for investigators and prosecutors and forces them to address their mind to the ingredients of an offence before a charging decision is even made. It also includes guidance on bail, forcing the prosecutor and the police officer to address the grounds on which you might oppose bail. And most importantly, it includes a standard operating procedure that demands early and continued engagement between the investigator and the prosecutor. And we're already seeing the results here in Kenya with an increase of 17% of the number of ivory cases that are successfully prosecuted. And we're also seeing for the first time major traffickers now being prosecuted. And that's really down to that early engagement, prosecution-led approaches to investigation. It's a very simple solution, but it has a very big impact.
All right, and now to the next scene, which is all about the first day of trial.
Thank you, Your Honor. We are ready to proceed. Our witnesses, we have 3 witnesses who are presently not in court, but we can proceed as the officer just gets them.
All right, counsel, are you ready?
Your Honor, I wish to apply for an adjournment for reason that the prosecution have failed to disclose a vital prosecution statement, and therefore we will not proceed.
Is that true?
That appears to be true, Your Honor.
All right, well, I'll grant an adjournment. We'll list this case for trial on 5th of July. All rise.
Hey! I'm your witness, I'm here. This is the copy of my bond. What is happening?
Oh, I'm so sorry. This trial has been moved to 5th of July. Just come back on 5th of July.
But I just took a day off from work. And it took me 3 hours to reach here. Now see, the defendant's family are outside there and they're saying that I should look my back. I'm not coming back.
I'm telling you, if you're not in court on the 5th of July, I am going to arrest you.
What? What do you mean? You are threatening me. You are a witness. I'm not coming back. Then do whatever you like.
Court adjourned.
Now, according to Shamini, that sort of a scene is played out in lots of courts across many jurisdictions across the country and, in fact, across the continent.
A culture of adjournments pervades many courts at the expense of the needs of the witnesses and to the huge disadvantage to both the prosecution and, in fact, the defence. It leads only to witness attrition, witness fatigue. They don't want to cooperate anymore. You get case files that are lost. You get exhibits that get lost. You get transfer of personnel. Judges get moved off cases. Defence counsel change. Prosecutors change. The whole case suddenly becomes more and more compromised the longer and longer it drags on.
And now to the next scene where the prosecutor, acted by Liz Gitari, is ready to proceed. She has had a pre-trial conference, but the counsel is not ready to proceed for trial.
Your Honor, I'm not ready for reason that a vital prosecution witness statement has not been supplied. We pray for your kind indulgence that we get another date.
Is that true?
It does appear that that particular witness statement he's referring to was not disclosed, Your Honor.
What does that statement relate to?
It's just a ranger who happened along the scene of crime after the defendant had been arrested and the scene of crime had already been secured.
Does he give identification evidence?
No, he does not.
Is he here?
Yes, he is.
Was he on the list of witnesses that you gave to the defence at initial disclosure?
He was, Your Honor.
Counsel, when did you inform the prosecutor that you hadn't received that statement?
Your Honour, we didn't.
Counsel, when did you inform the court that you wanted this case listed for a mention to seek an adjournment of this trial?
Your Honour, we are sorry, we didn't.
All right, well, I'm extremely confident in your ability to digest this statement over the lunchtime at break. Madam Prosecutor, you may have to call that witness out of term this afternoon, but we have witnesses waiting, Mr. Abwar. The trial will proceed as planned.
Court adjourned.
And that was the end of the mock trial. The final scene, Shamini, now summarises all the events.
The difference between those two scenarios, again, is a very simple one again. It's about management of the case by way of a judge-driven process that demands that the prosecutor and the defence play their part. It's a simple change of expectation. Here in Kenya, a pilot called Active Case Management was launched in December 2015, and it was launched in 3 pilot courts. And we're already seeing, just 4 months on, an increase in the effectiveness of the first trial hearing. We're seeing a decrease in the number of adjournments between those cases. And of course the buy-in, again, for achieving a buy-in for a pilot like that, lay in achieving or obtaining proper data in the way that cases are being handled in the courts, because it provides an evidential platform to then go to the Chief Justice, to go to the head of a judiciary and say, this is what's actually happening and these are the solutions. So unless we address, as I said at the start of this, the way in which decisions are made on charges and bail, and the way in which cases progress through the trial, all our efforts at training and sensitisation of judges will not have the desired impact that we want, if the desired impact we want is a high rate of convictions and a deterrent effect upon would-be poachers.